We're still unpacking what the reversal of Roe v. Wade and the arguments justifying it mean for our future. To do that, we can also look to the past. You know, the preamble to the Constitution says, we the people in order to form a more perfect union. That's how it starts. You know, the we in there, it didn't apply to a lot of us. It certainly did not apply to me. The founders did not have women in mind. They didn't have black people, brown folks, any people of color in mind when they wrote it. Not the LGBTQ plus community. It was written for white men who owned land. That is who the we was. So with that, I want to bring in legal and cultural historian Linda Hirschman. She is also the author of The Color of Abolition, How a Printer, a Prophet, and a Contessa Moved a Nation. Welcome, welcome, Linda. I'm very excited about this conversation. I'm very excited because earlier in the show, we were talking about the concept of originalism as it relates to the Constitution. And we know that the court's opinion on Roe really relied heavily on the philosophy of, quote, original intent. Can you speak to the implications of that philosophy and its origins?
Well, it actually goes back pretty far, right? Like the founders had an argument about it. Madison and Hamilton actually argued about it because Hamilton wanted to start a bank. And Madison and Jefferson, enslaving holders, founders, said that the Constitution did not allow the federal government to start a bank. So the argument goes back a long time. And it turns out that at no point did anyone ever establish that the framers of the Constitution intended it to be read only in its original intent? There were many of them. They had a lot of different opinions about what the document was and how it should be read. And they argued about it from the moment it dropped and well into the years at the founding of the Republic. They argued about it. Madison, who was like the big cheese in the constitutional arena, actually changed his mind. He went from saying that, you know, the Constitution should be limited to what it explicitly says to saying that the Constitution evolved over time. And what I think really matters is that people figured out repeatedly that if you could turn the clock back to the moment before people were trying to get included in the American project, you could keep them out. So it really happened twice.
It happened twice.
After the Constitution dropped, and then there was the Jacksonian Revolution when they started including people who didn't own land in the. And then it happened after the Constitution was rewritten by the Civil War amendments, and when the evil villains who rolled back Reconstruction got their hands on the court again, they read the Civil War amendments as if they, hilariously, did not actually apply to Black people for whom they were manifestly intended. Can I just say one more thing about Dobbs?
Yes, Linda, I was going to ask, but please go ahead. I mean, I can listen to you all day long.
Thank you. The court in Dobbs did not say that the Constitution is limited to rights that are expressly set forth, like freedom of religion or freedom of speech, although that would be sufficient to protect abortion, in my opinion. They said, no, actually, now and then we can go back and cook up a self-serving version of our history and traditions that supports the outcomes that we want to have happen now after the Republican Revolution.
So, Linda, I guess I'm sorry to interrupt you, but did the framers give us any clues? Or are there any clues within the Constitution about how it should, in fact, be interpreted for generations to come? Because people have this conversation about original intent, and I think you just so adequately laid out here why, you know, that is just not enough. But are there any clues there that we could, you know, glean from?
Well, there is the necessary and proper clause, right? I mean, the framers thought, we're going to tell you how to run the government, and we're also going to say you can do anything necessary and proper to the ends that we have described. So there was a very good argument that that language meant a living constitution. right? My favorite answer to that question. So, yes, the framers did give us some guideposts. And if you think about the Constitution as a document that they were setting forth for the ages, and where they said you can do anything necessary and proper, and there are historical documents about what they were thinking, you have to say, what is the American project that they set in motion about? And the absolute best thing I've ever heard on that subject was from Ruth Bader Ginsburg. I know she's not much in fashion right now for taking a chance that cost us this ghastly price. But she did say the American project is a project of ever expanding circles of citizenship. So it started with the rich white men that you described. And then Jackson brought in white men who weren't rich. And then the Civil War amendments brought in Black men, and to some extent, in the abolition of slavery, Black women. And then the 19th Amendment brought in white women, and the Civil Rights Movement brought in Black men and women and white women. So it was a story of ever expanding circles of inclusion. And as your prior panel pointed out, what is happening now is that the Republicans of the MAGA revolution have slammed that door.
Linda Hirshman, will you come back?
I'd be delighted. Thank you so much for asking me.
Thank you. Thank you for being here. This ever-expanding it continues to expand. And look, it's a democracy if you choose to have it, if you choose to fight for it. And that's what folks are trying to do every day. Linda Hirshman, thank you for being here. I appreciate you.